When can you modify court orders based on the child's best interest? Imagine your family situation changing suddenly, and you're wondering if you can ask the court to change the custody or visitation plan. Well, in family law, court orders about children can be changed when something big happens that affects the child's well-being. The court looks at whether the change is in the child's best interest. This means the court wants to see if the new situation will make the child's life safer, happier, and more stable. To get a court to change an order, you need to show that there has been a significant change in circumstances since the original order. For example, if a parent moves to a new city, gets a new job, or starts a new relationship that impacts the child's environment, that can be a reason to ask for a change. If there is evidence of abuse, neglect, or domestic violence, the court will consider that too. Changes in the child's needs, like health issues, school requirements, or emotional support, are also important. Another reason to ask for a modification is if a parent cannot provide a safe or stable home anymore. For instance, if a parent becomes seriously ill or has problems that prevent them from caring for the child properly, that could be a reason. Changes in the other parent's ability to care for or visit the child, such as returning from military service or health issues, can also be grounds for modification. The court's main goal is always what is best for the child. They want to make sure the child's safety, emotional health, and stability are protected. When a parent files a request to change a court order, they must submit a formal petition to the court. If both parents agree on the change, they can work out an agreement. If not, the court will hold a hearing to review all the evidence and decide. The child's voice can matter too. Depending on how old and mature the child is, the court might ask for their opinion. Sometimes a lawyer or a guardian ad litem is appointed to representing the child's best interests. For single parents, it is helpful to keep detailed records of any changes that affect the child's life. This might include medical records, school reports, or proof of changes in living arrangements. Being clear and organized helps when presenting your case. Sometimes, parents can work together through mediation to agree on modifications without going to court. But if they cannot agree, the legal process will take its course. Once the court reviews everything, the judge will decide if the change is in the child's best interest and if there has been a substantial change in circumstances. If both are true, the court will modify the order to better suit the child's needs. Understanding when and how to seek a modification is key for single parents trying to keep their child's best interests at heart. It is always about making sure the child's safety, stability, and happiness come first.